And we're here with Justin Florence, who is a fellow at the Georgetown Center on National Security and the Law, and a civilian attorney of Mr. Hamdan, who was recently convicted on one count before the military commissions that were recently concluded. We were talking about the way in which evidence was obtained and used in some of the trials, and I'm curious as to Justin's perspective on how any highly coerced evidence may be used later down the road in similar type of situations.
It's one of the problems with the military commissions is the evidentiary rules. In this case, I think the judge made some thoughtful and considered decisions about what evidence he would allow in and would not. But the rules of the commissions themselves, both in the statute that Congress passed and in the more detailed rules from the Pentagon, do allow in coercive and sort of, some would say, tortured evidence in certain situations. And there are some real legal problems with that. It's inconsistent with all of our sort of basic American notions of due process, with the Constitution, with the Geneva Conventions, and it's one of many of the real problems with how the commissions are established that it will be interesting to see how it plays out in future trials.
I mean, I think that would be particularly relevant in the trial of any of the high-value detainees in which the administration has purportedly used enhanced interrogation methods such as waterboarding, at least in a few cases.
I think it absolutely will. And one thing that you see here is the administration has been using what some call clean teams to sort of go through evidence about or from the detainees and scrub out evidence that the administration is comfortable using because it didn't come from these sorts of methods, from information that has been derived from these less clean, as they say, sources and methods. And it will be a challenge, I think, in other cases for the administration to come up with evidence that's not tainted in that way.
Many argue that this case, notwithstanding flawed commission process, really is an illustration of how justice can be served. And my question is, in light of the fact that it was a split decision in terms of convicting him on one count and not on another, and a greatly reduced sentence for Mr. Hamdan, would you say that this was a fair process, or would you say that it at least bolsters the claims of those who say that it has some legitimacy?
I think it can, in certain cases, have legitimacy. In a case like this, where the judge and the panel members took their responsibility very seriously and deliberately, I think the process, as they handled it, went well and was fair and legitimate. That said, there are some major problems, even in this case, which looks like a big sort of success story for the rule of law, with how the commissions are set up. And just one thing that's gotten talked about a little bit in this case is the substantive offense for which Mr. Hamdan was convicted, the so-called material support, has never before been considered or used as a war crime. You've never been become a war criminal for giving material support to a terrorist group. And that raises big legal issues under the ex post facto clause, for example, as to whether you can prosecute somebody in a military commission for something that wasn't a crime when the conduct happened. So that's just one of the many different types of issues. There are still issues with hearsay evidence, with access to witnesses, with Geneva Conventions, and other things like that, that I think are likely to be under consideration on appeal, and that may reveal that even a case like this that looks like it was fair and just has some major flaws to it. Another whole problem here, which is worth getting into a little bit, is that the administration, both before and after the conviction and sentence came down, has taken the position that whether or not people in the military commissions are acquitted, and no matter how long their sentence is, it can continue to hold them as long as it wants. And in a case like this, where Mr. Hamdan's sentence should be run in the next 5 months or so, the administration may well, and it's given every indication thus far that it intends to, just continue holding Mr. Hamdan in Guantanamo as long as the president wants. That's obviously still up in the air a little bit, how the administration is going to handle that, but to the extent that people are held, whether or not they're acquitted, whether or not their sentences run, it sort of makes these commissions seem very much like show trials, where it's heads we win, tails you lose, and
that
you're
would
stuck.
That would certainly seem to me like a arrow through the heart of justice and the rule of law when you're having a trial system, which the result really has no bearing on the ultimate ability of those that are detained to go free. So do you anticipate, now that Mr. Hamdan's trial at the commission level is concluded, do you anticipate that the administration will move quickly to try other detainees?
Yes, it's said that it intends to. There are several other detainees, including some of the so-called high-value detainees who had been charged and are in pretrial proceedings. And there's also still some ongoing proceedings in the federal courts to attempt to block those trials, but I'm very sure that the administration will want to get as many of these under its belt before the November elections as it can.
Great. Well, that's all the time that we have for now, but again, I want to thank Justin Florence, who is a fellow at the Georgetown Center on National Security and the Law and a civilian attorney for Mr. Hamdan. Thank you very much for joining us.
Thanks, Rob. I appreciate it.